We have a massive update on the Houston Wade case following the most recent omnibus hearing, and things have taken a dramatic, unexpected turn behind the scenes. If you thought this case was heading toward a quiet plea deal, think again. The defense just drew a line in the sand. Here is exactly what went down today, and what it means for the future of this case. First, let's talk about who is actually running the show for the defense. If you've been tracking our previous updates, you know that Houston Wade started out with a public defender, Aaron Talney, before private attorney Shannon Polly took over for his last two hearings. Today, there was a total shift. Shannon Polly was completely absent from today's record and wasn't mentioned once. Instead, the case appears to have been internally reassigned upward to the firm's partners. Attorney Jesse Williams appeared in court today. However, he wasn't there as the primary trial lawyer. He was standing in to cover for his law partner, Ms. Farina, who is currently tied up in a trial over in King County. What does this mean? Well, when a private firm quietly shifts a case from a senior associate to a firm partner, it usually means the kid gloves are off. They are restructuring for a heavy legal fight. The biggest bombshell from the hearing is what wasn't said. There was absolutely zero mention of a plea deal, ongoing negotiations, or a settlement. Instead, Jesse Williams laid out an aggressive new roadmap. He explicitly told the judge that the defense is currently finalizing a formal motion to dismiss and intends to litigate it in advance of the trial date. What does litigating before trial actually mean? Instead of waiting for a jury trial in September, the defense is forcing a high-stakes, standalone showdown in July. They are trying to trigger a legal kill switch. If they can convince the judge that there is a fatal flaw in the state's case, whether that's a severe procedural defect, missing evidence, or a lack of legal standing, the judge can throw the entire case out before a jury is ever selected. Because of this aggressive new strategy and summer vacation schedules, the previous trial date of June 29th has been officially stricken. The court coordinated with the prosecution and locked in a brand new timeline. There will be an omnibus and motion to dismiss hearing on July 20th and a new trial date of September 14th. The defense has given themselves until July 20th to launch their attack. Because they kept their cards close to their chest in today's hearing, we don't yet know the exact legal technicality they are using to try and drop the gavel in this case. It could be an issue with how evidence was handled, a delay in discovery, or a specific statutory defect. As soon as that written motion to dismiss is officially filed with the court clerk this July, we will pull the public records, break down their arguments, and see if the defense actually has a winning hand, or if they are just testing the prosecutor's resolve. Stay tuned, hit that subscribe button, and let us know in the comments. Do you think the defense can pull off a total dismissal in July? Or is this case bound for a jury in September?